Hey guys, welcome back to today's video. Buckle up because this one is packed. We're breaking down multiple court hearings, and each one somehow escalates beyond the last. First, we revisit a familiar figure, Stephen Cooper, the same individual who ignored court orders, repeatedly appeared on Zoom after being instructed to show up in person, and ultimately pushed a judge to issue a bench warrant. After attempting to evade the consequences, his luck ran out, and he's now been sitting in custody. We'll look at 3 brief hearings where Cooper suddenly asks for leniency, hoping the court overlooks his past behavior. But the judge isn't entertaining it for a second. Then, we shift to another case featuring a sovereign citizen who enters the courtroom armed with recycled arguments, only to be swiftly shut down by a judge who's heard it all before. If you're ready to see confidence collide with reality and weak arguments dismantled in real time, let's get started.
Let's go ahead and call Mr. Cooper while we're waiting. All right, this is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper's before the court today. He represents himself. Mr. Cooper, do you still wish to represent yourself?
Yes, Your Honor.
All right, there's been a bunch of motions filed today, but print out the motion that I've denied, most of the pro se, the ones that were filed as of the 12th. Madam Clerk, dismissed, the motion to dismiss defendant's motion to reinstate bond and vacate related bond forfeiture, and notice of speedy trial.
Development resubmitted.
Yeah, and I'm gonna deny them again. All right, where we at? I dismissed the pro se notice of speedy trial demand. But okay, we'll set it for the November. Anything else, Mr. Cooper?
Yes, you dismissed them because of a certificate of service, and they were refiled with a proper certificate of service.
They were just refiled today. I have not had a chance to look at them. So I won't deny them today. I'll just reserve on that, okay? I just have not, they were not in the court file when I looked this morning. They were filed today. So I'm not prepared to order them. I will not dismiss them today, but I will have a chance to look at them, okay?
So I have a right to reinstate bond?
No, I'm not reinstating it right now. And I'm not gonna reinstate your bond. You failed to appear. Judge Costello, my understanding that Judge Costello was covering for me, that you appeared by Zoom, and you did not come to trial as you were ordered to, so you're not getting back out of jail.
It was not willingly, though.
You're not getting out of jail, Mr. Cooper.
But I have a right to bond.
Denied. All right, well, denied.
I do have a motion that I'd like to submit to you.
You can submit it.
Disqualification of judge.
Okay, submit it.
Who should I hand it
To the clerk. We'll set that for the 19th, and we'll have a chance to look at the other ones, okay? That's Friday morning.
Let me be clear. Judge Clark is not someone you try to outmaneuver. He's already heard every excuse, every delay tactic, and every weak argument. And he has no intention of releasing someone who has repeatedly failed to appear, only to risk the same behavior again. At this point, there's no patience left and no tolerance for games. We've got 2 more brief appearances in this case, and rather than breaking them down moment by moment, I'll let them play through, because even in these short clips, it's obvious why the judge refuses to budge.
State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper's present in the courtroom. He's representing himself. Mr. Cooper, do you wish to continue to represent yourself?
Yes, Your Honor.
And we're set for trial November 3rd. All right. Did you get the order to deny motion for disqualification of judge?
I have not received that.
I'll have that printed out for you. There's some other motions that you filed. Looks like we got them yesterday. What I'm going to do is I'm going to leave this on the trial docket for that November date. I'm going to set this for October 24 for a trial management and motion day.
I got the bond reinstatement that was previously filed, and then...
Yeah, I'm going to deny that motion for bond. You're based on your failure to appear. I'd already, and for the record, I have had you arrested at least once on a failure to appear, released you again on, allowed you to go back to, I believe, Ocala. On the morning of trial, after you filed a demand for speedy, you failed to appear, and Judge Costello revoked your bond at that time, had a capias, and then we had to, I think the capias was outstanding for a while. So my motion is denied.
I'm prepared to make arguments in regards to that.
Well, I'm not prepared to listen to them. I'm ruling on your motion, okay? But I can rule on a motion without hearing an argument, and that's what I'm doing today. Anything else?
Any of the other motions?
I'm gonna hear everything on the 24th, because you just filed a bunch yesterday on the 16th. We got them in the court file, so I'll hear everything the 24th. That will conclude today's hearing. Mr. Cooper, we'll see you then. Mr. Cooper, you're here today on your trial management. I believe you're set for trial November 3rd at 8:30. You're representing yourself. Do you wish to have an attorney appointed to represent you or talk any more about that?
No.
Okay. All right. Where are we at?
I believe it's the motions, and I have my motion to reinstate bond. And
That'll be denied.
all the motions filed on the 14th that you postponed 30 days until this date, and none of them have been responded to.
Filed a traverse, responding to his multiple motions to dismiss, the motion for discharge, and the motion to quash the information.
All right.
Actually, a motion to disqualify the judge was filed as well. I believe you got that.
I think I've ruled on that, hadn't I?
I believe you got another one.
All right, I'll get you in order to that next week. We'll leave it on the docket for November 3rd. See you then.
Are you going to give me the traverse? I haven't received anything.
Yeah, if you don't have it, the state has this already been filed, so if you want to give it to him, or the clerk office can give it to him.
Let's just say his approach to handling court orders didn't exactly work in his favor. While he did have a trial on November 3rd, that proceeding wasn't streamed, so there's no footage available. But it's a safe bet that a verdict was reached, and he remains in custody facing the consequences. With that chapter closed, we shift to Judge Meyer's courtroom, where things escalate quickly. This time, an American state national steps in, armed with familiar arguments. But he's up against a judge who knows these tactics inside and out and has no intention of entertaining them. The audio may be rough, but I've done my best to make it clear, because this is one exchange you won't want to miss.
Amos Canzoni, come on up and have a seat if you would. Go ahead and have a seat, sure. There's no contract. You and I have no contract. We resolve it in this way. It's a civil infraction, which means the city has the obligation of going first. Go ahead and have a seat and speak into the, if you're more comfortable standing. No, this isn't the time for questions. This isn't the time for questions. What we do here, this is not, we do it in a certain order. The first thing we do is, as you were cited for 2 infractions, is as I read what the officer said, until there's nothing before me, until we have the officer's statement. Once we have the officer's statement, then you can present whatever argument you want. That's the time you make your argument.
So what is it called today?
Pardon?
What are you planning on doing today?
Well, you're defending yourself against the issuance of 2 infractions.
No, I'm not the defendant.
Well,
would you agree with me?
you're whatever you want to call yourself, a defendant, a respondent. You're the person who was issued the citations.
That's the problem. That's not the defendant.
I've read the argument. You're not raising it at the right time. Raise the argument after I've read the officer's statement into the record.
I have actually contested that statement on the return service that you received in the file.
Right.
Statement is not accurate.
If it's not accurate, now is not the time. We don't have the statement yet. I need to read the statement. On January 2nd, 2025, at approximately 1600 hours, while on patrol within the city limits of Yelm in a marked patrol vehicle, when I observed a silver Buick traveling east on Mossman Avenue with Washington registration ACA 8168. The registration showed expired as of 11/24. I conducted a traffic stop using my emergency lights. The driver was identified as Amos Canzoni by his Washington State driver's license. Amos first gave me a random card stating he was an American citizen and did not need a driver's license. Amos attempted to argue his sovereign citizenship and that he did not need a driver's license. Amos was unable to provide me with current proof of insurance and stated he did not have any at this time. Amos was given the opportunity to contact the valid driver who was unable to do so. I advised Amos that his vehicle would be impounded Amos was given a criminal citation for driving while license suspended in the 3rd degree, a traffic citation for no insurance, and a copy of the TOEFR. Amos was given a courtesy to his residence. The vehicle was impounded from the scene by Wharton Towing. That's what the officer said. Now I'll listen to you. Now's the time.
Let's be clear. This wasn't traveling or operating under some imagined exemption from the law. He was driving a vehicle he didn't legally own, without a valid license or insurance, and when officers attempted to verify ownership, there was no legitimate individual or documentation to support his claims. With no proof and no accountability, the vehicle was lawfully towed. Situations like this highlight a broader issue. Relying on fabricated legal theories doesn't just create problems for those involved. It wastes time, strains resources, and impacts everyone around them. And now, with that context in mind, let's see what he believes his so-called sovereign citizen credential will accomplish here.
Could you speak into the microphone?
I gave the officer very first once when he approached me, I gave him this, my American State National Credential Card. And this has all the information he needed to look up to find out that I'm not a US citizen and therefore not in his jurisdiction. And therefore, there's no issue about traffic violations because there was no crime involved. And then he refused to look up the information by his own choice. So then he required my driver's license, which I told him I can give it to him, but that does not apply because it's my license, it's not the DOL's license, because my name is a copyrighted name. And therefore, it's in my possession. But anyway, he then went on to saying about sovereign citizen. That's an oxymoron. And I tend to say only morons use that term because a sovereign can never be a citizen. Citizen has an obligation to whatever government or state he's subscribing to. Whereas a sovereign, I'm a foreign sovereign. I mean, I'm foreign to your jurisdiction. I'm here talking to you now as a lawful person. I can talk to you because we're both persons in this environment, but I'm not subject to legal rules and everything. That's up to you. That's you are subject to. I'm not. I tried to tell that to the police officer because for his own protection, I told him, look, I'm not really who you think I am. I'm a driver, not driving a commercial vehicle with interstate commerce, which is the only reason I would have a driver's license. So that's why I gave him the credential card first, so he could correct his mistake. He refused to do so, and they ran me through the mill, and you know what the mill was doing afterwards. So that's all criminal now because I'm a foreign sovereign, and I posted it on my door. I posted it in my file that I have the Foreign Sovereign Immunities Act, meaning help that holds me, a man, a lawful person, immune towards the legalese, the legal subscription which a dual citizen has obligated.
Let's clear this up, because this is where the argument completely falls apart. The Foreign Sovereign Immunities Act has absolutely nothing to do with a personal traffic stop, none whatsoever. What makes it even more striking is that he openly admitted in court that he was driving, not traveling, which immediately undermines his entire position. For clarity, the Act is a federal statute that governs when U.S. courts can hear cases involving foreign governments, primarily in matters of commercial activity and international relations. It has no relevance to individual conduct on public roads. You cannot simply declare yourself exempt from the law through labels or terminology. Legal obligations don't disappear based on personal belief. No matter how it's framed, the law remains firmly in place, and it applies just the same.
Obligations. And I tried to tell you that too in my paperwork as a meeting. And so you don't have a claim. You have to actually prove jurisdiction over me, one here. Defendant is not me, but defendant, the name, all caps name, is under my private copyright and trademark. So you basically created, not you with you, I mean the federal government created that name. And I'm asking you, do you agree that the name represents a usufruct derivative? It's something you can use to access my assets and create credit therefrom, and then without my consent or knowledge, you can then create monetary incentives for yourself and for the court and everything. But the credit and the asset still belongs to me. So the conundrum I have with you now is, you are the ones who would have to pay the fine on that violation because it doesn't concern me. It concerns a usufruct derivative, which I still don't have any control over, even though it's in my copyright and trademark. That's the whole conundrum I have with the court and with the federal government itself. You trespass on me, you basically transform me into a defendant, all caps named defendant, which I am not, and I have proven that I'm not. And yet you still try to link me to that case with that defendant. And I would claim that the government is responsible to offset all these fines or whatever you want to create under that name and hold me harmless because I have nothing to do with it. So that's, in a nutshell, the situation. But I would also say you have to prove jurisdiction first before you have a case. And you haven't done that so far. Nobody has rebutted my documents I filed into the court case. That means in your own rules, it's admitted truth because it has not been rebutted. It's fact and truth. And then you would technically have to honor these facts and truth. But by continuing with this charade, you do not. And you do not recognize that you're basically now in criminal contempt of the law because do I have to spell it out? As of January 1st, 2025, poof, this court has disappeared. The municipal government has been liquefied with a Chapter 7 bankruptcy, which has been finalized January 1st. And now, basically, you don't even exist anymore. Or if you do exist, you would have to be on Washington, D.C. ground because you're not having any rights to be on land and so on.
And this is where the distinction becomes clear. So-called American state nationals present themselves as something different, but in practice, they rely on the same discredited arguments often associated with sovereign citizen claims, just framed with more elaborate language and greater confidence. The core ideas remain unchanged, repackaged with pseudo-historical references and legal terminology that create the illusion of credibility. In the end, it's a difference in presentation, not substance, and the outcome tends to follow the same predictable path.